started. Kyle, how do you say your last name, Kyle? Or is it Kyle?
It's Najat.
Najat. Okay, awesome. I looked at that, I was like, oh, I'm going to get that wrong.
Don't worry.
All right. Well, I think let's go ahead and get started to give our sponsors enough time to get through their materials. So thank you so much, everybody, for joining us today for the presentation. I am Hannah Cole, Associate General Counsel for Employment Matters at BD. I'm also a board member of the ACC San Diego chapter and the Vice President and co-chair of our programs committee. We are incredibly excited to be joined today by our sponsor, Higgs, Fletcher, and Mack, who are fantastic supporters of our chapter. With us, we have two attorneys who will bring their unique perspectives to the topics of the changing employment law landscape. First, we have Rachel Gerard, an appellate attorney focusing on both civil and criminal appeals. She will share her insights on preserving appellate rights and setting employers up for success. And she handles high-profile appeals in all state and federal appellate courts, including appearing before the Ninth Circuit and the California Supreme Court. And in her spare time, she's also an advocate for victims of human and civil rights violations, and recently helped obtain political asylum for her client, a child who fled Guatemala to escape gang violence and abuse. So we're very excited to have Rachel. Also joining us is Kyle Najat. Did I get that right? You just told me. That's excellent. Okay, Kyle Najat. And Kyle represents employers in all types of employment matters, including class actions, discrimination, wage and hour disputes, trade secrets, and hopefully for us today, claims under the California Private Attorneys General Act, which I can say from experience is a nightmare for California employers. Kyle was also the past chair of the California Young Lawyers Association, which is the largest association of young lawyers in the nation. And in that role, he advocated on behalf of more than 50,000 members in California and worked to provide training and continuing ed opportunities to new attorneys across California. So we're very excited to have these two fantastic attorneys with us today, and I will turn it over to Rachel and Kyle.
Great. Well, thank you so much, Hannah, for that introduction. I'll go ahead and share our screen. We have a PowerPoint. We promise we won't kill you by PowerPoint, so we'll keep things light, but we'll go ahead and share it so we can talk about this very timely topic. So we're here to talk about, as the title indicates, what really is what could potentially be a seismic change here in California dealing with arbitration, the Private Attorney General Act, and related appeals and matters, all connected, and they're all interconnected, and we'll get into that in greater depth. And Hannah just did a great introduction for Rachel and myself, but just quickly again, we'll jump through it. So as Hannah indicated, I've spent the last 10 years representing employers in state and federal court across the state of California. I only do employment litigation, only represent employers, primarily litigation, but especially during COVID, a lot of advice, a lot of counseling, a lot of how do we handle X, Y, and Z, whatever public health order came down. So the last couple of years have been kind of exciting for me, doing less litigation, more actually working with in-house counsel and HR folks directly and helping them get through the pandemic. And Rachel, as Hannah indicated, is one of our great appellate attorneys here at the firm. And I can say, well, it might be untimely or premature that she has passed the certification and is now a soon-to-be certified specialist for appellate law here in California. So that's awesome.
Yeah, so I like Kyle, who does exclusively employment litigation. I do exclusively appellate work. I represent individuals and entities in appellate proceedings throughout California, in state and in federal courts. I do mostly civil writs and appeals, and a lot of times those appeals involve employment matters, especially given the prominence of the employment department here at Higgs, Fletcher, and Mack.
Who we are San Diego's oldest law firm, but we represent employers in state and federal courts across the state. A lot of our work is in Los Angeles and San Francisco. So while we're based here in San Diego, we definitely do work wherever our clients need it. And as Rachel just indicated, we have 14 attorneys in our employment law group. And our wonderful appellate department helps us, as Rachel indicated, on all of our appeals and is well versed in employment law.
Just a quick note that if you do have questions that crop up during today's presentation, you can go ahead and enter them in the chat. We probably won't be monitoring the chat in real time since we are going to be sharing our screen with the slides. But to the extent there's anything there on the back end, we'll try and leave a few minutes so we can touch on any topics that come up in your minds.
So let's start with what is PAGA, and we'll go pretty high level through this because we want to get to the arbitration issues and the recent case law about the changing landscape of arbitration in California. But we'll just start with some background. And as Hannah aptly noted, PAGA is a mess, and it's a mess for California employers. It was created in 2004. It was a way for the legislature to not have to, frankly, fund the LWDA, which is the Labor Workforce Development Agency, and allow everyday citizens to bring lawsuits against their employers on behalf of the state of California to recover civil penalties for labor code violations. As the second bullet point notes, and it'll become important later in the presentation and later as we discuss about some of the landmark cases with PAGA and arbitration, the individual employee who's bringing the lawsuit actually isn't the real party in interest. The real party in interest is the state of California against the employer. And while the named plaintiff is on the pleadings, they're actually representing the state, and they actually don't have any property rights in the PAGA action.
So the word you hear in this context is the word deputizes, right? The state deputizes individuals to bring these claims on behalf of the state.
So if you are familiar with the federal key tam statute, it's kind of like that, except with, and we'll get into this in a moment, with the key tam action, a percentage goes back to the government, and the plaintiff who's been deputized gets a percentage of what remains. In a PAGA case, while the state gets 75%, all the aggrieved employees will get a share of the 25%. Whereas in key tam action, only the named plaintiff would keep the remaining dollar. So how did we get here? Initially, if you look back at the legislative intent back in 2003, the PAGA was intended to not be a mass tort action. It was intended to primarily help farm workers in the Central Valley who the legislature thought needed additional protection. And the idea was, again, if you look at the legislative history, that people working on an assembly line or in the same office would see labor code violations occurring against not only themselves, but against their coworkers, and then they could bring an action to collect civil penalties on behalf of the state. Of course, what happened, though, it's not just with a small group of people. The PAGA has now exploded into the largest form of employment litigation in California, far surpassing class actions, and we'll get into that in a second. And what's happened is, while it wasn't intended to be a mass tort action, it has become the litigation du jour for the plaintiff's bar. And as I indicated earlier, as it says on the screen, so 25% of any penalties collected will go back to the aggrieved employees, and they're usually paid out based on the number of pay periods that they individually worked during the PAGA period. And then 75% will go back to the LWDA, or the state of California. And in the last 15 years, I think I read a report a couple months ago, the state's made billions of dollars by this device through the 75% of the penalties going back. And then if you took a case all the way through trial and judgment was entered against an employer, the defendant, attorney's fees would be awarded in addition to any civil penalties, which the attorney's fees, as you can imagine, as we had in class actions in the 2000s and the 1990s, are massive in these types of representative claims.
And attorneys can recover on their fees even if the PAGA recovery is quite small, right?
Correct. And that's true if you do any fee haul litigation. It's what's reasonable, what's the reasonable attorney's fees, but that word can be construed in any way that a court will take it. So as I've indicated at the top, these claims, what are PAGA claims? What is PAGA is just a procedural device. It doesn't create any new violations. It has to be predicated on some labor code violation. And what we see, this is not an exhaustive list, but what we see most often is the meal and rest breaks, the off the clock work. So that's my manager made me clock out and continue to work. Overtime claims, I wasn't paid appropriately, wage statement violations, and reimbursement claims are big ones. And what we're seeing now as part of kind of the post-COVID, during COVID phase of PAGA litigation is the reimbursement claims are becoming kind of a go-to, just the work from home. If employers weren't appropriately reimbursing their employees for example, internet or power or office supplies, et cetera, that's now what we're seeing slowly pick up since it didn't happen, frankly, the first year of the pandemic, but over the last 6 months, that's kind of been the go-to. So it's definitely what's new and next. The meal and rest break claims, frankly, if everyone's working from home, it's kind of harder to justify that because of course the employee could take their breaks whenever they want. So plaintiffs' attorneys have had to adjust and we're seeing more of that. So as I said, it's not a class action. There's no procedural device to protect the employer before a PAGA case can proceed. As you may know, in a class action, the plaintiff has to first overcome the first hurdle, which is class certification. They have to show the court that they can adjudicate their claims on behalf of the class in what the Supreme Court has said in one fell swoop, that common questions can be asked and common answers can be provided. There's some serious, significant due process issues with that, right? And that's an issue that is still up for debate, and appellate courts have been dealing with that for the last 15 years.
You mean like hundreds, if not thousands of individuals potentially needing to be called to testify?
Correct. And that's the next point is, under a class action, you could have the named plaintiff and a couple other people come in, testify as to their experience, and then have an expert come in and opine that this would apply to everyone else in the class or use data available. Here, some courts have said that those types of procedures are appropriate in a PAGA case, that we can just adjudicate it based on the testimony of a few individuals. But in reality, what the statute requires is that a labor code violation has to be proven for every employee for every pay period. So to Rachel's point, we've successfully defended a lot of our clients in convincing the court that to do so would just completely overwhelm the court, that we would be needing to use the courtroom for literally 6 months, 8 months to bring in every employee and frankly cross-examine them on their purported labor code violations, which a lot of courts have. Like I said, we've been successful in this, have agreed with us that would just be unmanageable and would be, would completely disrupt the court system. And so that's a kind of a way that we've been pushing back at, these PAGA cases. Finally, just quickly, again, in a class case, you have the class certification device that you can use as a sword, not just as a shield, to delay discovery of class claims and on behalf of absent class members. But in PAGA, the California Supreme Court has said, at least for contact information, and there's been some additional appellate court decisions that have supported this as well. In a PAGA case, it's open season, and you can get class-wide, well, not class-wide, excuse me, PAGA-wide representative discovery from day one. So what happens if a labor code violation is discovered or proven? The court can award up to $100 per pay period per employee for the initial violation. As I said, the court has discretion, and that discretion is really what we use as part of our settlement negotiations or the mediation in these types of PAGA cases. The understanding that even if a labor code violation is found to have taken place, the court might not be offended by it. For example, if it was, a rest break case where you have a good rest break policy, it's not facially illegal, and you had good procedures in place, but the court believed the plaintiffs that they weren't able to get their rest breaks on certain occasions, the court might say, I'm not going to award $100 per pay period, I'll give $10 or $15 per pay period. So that's very helpful in mediations. But at the end of the day, going back to what Rachel said, even if it's a much smaller dollar amount awarded, the attorney's fees that would come on top of that would be significant.
So let's turn now to the recent case law regarding PAGA, and in particular in the context of arbitration. So contractual arbitration, as I'm sure you are all familiar, is when parties agree to a contract to resolve future disputes through binding arbitration rather than in court or otherwise. This typically involves one or more arbitration clauses or provisions as part of a broader agreement. These provisions are extremely common in employment contracts. They probably exist in your employment contract and in the contracts that your company uses for its employees. Though, of course, they could be proposed in any context where parties are hoping to avoid litigating potential future disputes in court. Under California law, and this is CCP section 1280 at SEC, these provisions are considered, quote, valid, irrevocable, and unenforceable, save upon such grounds as exist for the revocation of any contract. Basically, that means ordinary contract defenses apply. Under federal law, which is the FAA, the Federal Arbitration Act, the standard is largely the same. And one point of interest, and this is something Kyle will touch upon more a little bit later on, is that in the employment context, these contracts can be entered into either at the outset, pre-employment, or at the time that an employee is hired, or they can be rolled out with existing employees during employment. We'll talk more about the particulars of these provisions, but first we're going to move a little bit into the rise in the prominence of arbitration and arbitration agreements. So the big thing, the talking and selling point about arbitration is its benefits. And this list will not be unfamiliar to most of you. With respect to the benefits, arbitration really promises a lot. It includes faster results, shorter and less costly proceedings, greater choice in the selection of your fact finder, including, for example, an arbitrator who's better qualified or has experience that's specific to the dispute in question. Oftentimes, arbitrations include greater privacy than judicial proceedings, and you can stipulate or include in your provisions certain privacy requirements for the arbitration, for example, to protect trade secrets. There's less exposure to runaway jury verdicts and punitive damages, and from a public policy standpoint, there's a reduced burden on the court. In addition, parties are more likely to engage in streamlined discovery and to benefit, at least on the employer side, from more reasonable settlement demands. And I know Kyle had a few words of wisdom on these last 2 points that he's experienced in his practice.
Yeah, I think it's critical when you're talking, especially to the business folks in your organizations about arbitration. They might just see a dollar amount and immediately want to reject it. And I think it's difficult to underscore that last bullet point and the power of being in arbitration. And what I mean by that is, when you're in arbitration and you don't have a jury that you can sell a story to that might not be supported by evidence, frankly, and you're going to be in front of a retired judge or a more seasoned attorney who's going to look at the evidence with a more critical eye, the plaintiff's attorneys are going to give you more reasonable settlement demands. They're going to know that the arbitrator is not going to give what a jury is going to give, and they are going to try to resolve cases in a way that is, efficient for them, so they don't have to actually litigate, but also recognizing that even if they hit a home run, the arbitrator is not going to give them, for example, unless it's really egregious, punitive damages. And so the benefits of arbitration, which are numerous, they're up on your screen. There's more of them, but the biggest one I see in my day-to-day practice is when I get a settlement demand in a jury trial, it's always insane, as I'm sure you've all seen and you've received from your outside counsel. And in arbitration, it's still insane, but less insane. So you definitely see a difference depending on the forum where your case is venued.
Though is that there are downsides, and that not all of the promises of arbitration can be delivered on in each case. So, for example, many cases that are initiated or compelled to arbitration end up taking just as long or costing just as much as they would have in court. In addition, streamlined discovery might mean that the parties are only permitted limited discovery, which may or may not meet the needs of the case. And this is something that you can account for in your arbitration provisions. They might find it difficult to obtain, the employer might find it difficult to obtain summary judgment or summary adjudication in arbitration, both because of the streamlined discovery and because if you recognize the human factor of having an arbitrator on the other side of this, they're actually disincentivized to get rid of their cases. Another thing is that arbitrators typically have high hourly rates, and those rates are paid by the employer, and that parties might find it difficult to join additional parties, for example, a non-signatory to the arbitration agreement, no matter how pivotal they might seem to the overall case. And so many employers learn on the back end of the case, there are extremely limited grounds for appealing an arbitration decision. I'll touch more on this sort of toward the end of the program, but one of the biggest downfalls from my perspective as an appellate practitioner is that arbitration decisions are essentially immune from judicial review. Again, a lot of these things can be addressed in the arbitration agreement itself, including these limitations on the scope and the grounds for appeal. And so companies often rightly presume that arbitration is the best forum for their disputes with their employees. So moving now to how arbitration provisions are litigated in California and federal courts. Recent changes in the law essentially mean these agreements may or may not be sufficient today. As a starting proposition, California courts and the legislature generally strongly disfavor arbitration in employment actions. While California does provide the detailed statutory framework in the CCP, like I mentioned before, the California Supreme Court has also held in Armendariz, this was in the year 2000, that employees can only be compelled to arbitrate their PAGA claims if certain minimum requirements or factors are met. Those factors include that the arbitration must include a neutral arbitrator, that there must be adequate discovery, a written award that's subject to some type of judicial review. And moreover, and perhaps most significantly, as I mentioned above, the employee cannot be required to pay any of the arbitrator's fees. So that's a big one for employers who are going to be asked not just to split the costs, for example, but to really foot the bill of these disputes. But the FAA sings a different tune. The FAA, the federal policy, the act embodies a strong federal policy in favor of arbitration and even preempts state litigation that attempts to restrict the enforcement of these agreements. So regardless though, courts have been conflicted for decades over whether the FAA preempts the California Act. Going through the case law and how this has evolved over time, I think the overriding principle that you'll see as we go through these next few slides is that there really is sort of a tug of war between California and the FAA. In Discover Bank in 2005, the California Supreme Court held that an arbitration clause containing a class action waiver was unenforceable in contracts of adhesion under California law. In 2011, the United States Supreme Court overruled Discover Bank, and that was in Concepcion. There, the court ruled that the FAA preempts state laws that prohibit contracts from disallowing class-wide arbitration, and therefore that class action waivers can require parties to bring only individual claims as opposed to as a class, and that was in Concepcion. A few years later in Iskanian, this was in 2014, the California Supreme Court did it again. It came back and restricted the enforcement of arbitration agreements by holding that even though the FAA preempts as to class action waivers, that doesn't really apply to PAGA claims. Its reasoning was that the FAA applies to private disputes, and as we mentioned at the beginning, PAGA actions are actually between employers and the LWDA. The LWDA, being the real party in interest, means that this is not a private action, and so the FAA does not apply, and this is according to Iskanian. So clearly you can see California takes an action, the federal court attempts to undo it, California takes an action, and we'll see what happens next. But clearly the law in California is in this state of back and forth. It's in a state of flux.
And one more thing that I'll just mention on Iskanian, another impact or something that the Supreme Court found was important to their decision was that not only is California the real party in interest in a PAGA case, California never signed the arbitration agreement. And that is additional reasoning, or at least what the court said, as to why the compelled arbitration clauses in arbitration agreements for PAGA claims would not be enforced in California. So Iskanian, as I'm sure a lot of you who do all this on a daily basis right now, is the law in California. So, continuing with what Rachel was talking about a couple of minutes ago about this struggle between the FAA and the federal courts and the US Supreme Court and the California courts, the California Supreme Court and the California legislature that has been going on for literally 15 years. As part of that, the legislature has been trying to figure out a way to get around the FAA. And it really is, if at first you don't succeed, brush yourself off and try again. You'll see on the screen, back in, I believe in the 2013-14 range, Governor Brown received from the legislature a bill to completely ban our arbitration agreements in the employment context. In his veto message, he said, look, at the end of the day, this definitely conflicts with the FAA. It's going to be preempted. The court's going to throw it out. I'm not going to sign it. A couple of years later, they tried again. The legislature modified some of the wording to try to placate the governor. Again, Governor Brown vetoed it, again saying this will not stand up against the FAA. And the US Supreme Court and its decisions and its president have made it clear that if there's a statute that's hostile arbitration, they're going to throw it out pursuant to the FAA. In 2019, a different governor was in the governor's mansion, and Governor Newsom signed what is called AB 51. And AB 51 is the most expansive change to arbitration and the labor code, and if companies can bring or force arbitration when their employees sue them. And it made it the mandatory arbitration agreements that we are so used to, we've been used to for many years, unlawful in California. Not only did it make it unlawful and say that if you force your employees to sign a mandatory arbitration agreement, you're breaking the law, the statute actually provides for both criminal and civil penalties available against employers and supervisors who are forcing their employees to sign these arbitration agreements.
And when we say forcing or compelling, we're talking about making the signature on the arbitration agreement a condition of the employment.
Correct. So if you want this job or if you want to continue in this job, you have to sign the arbitration agreement. After the passage and the governor's signature on AB 51, the U.S. Chamber of Commerce and the California Chamber of Commerce, a large group of business organizations, filed a lawsuit challenging the bill, and an injunction was issued. And primarily, as I was stating earlier, the issue becomes this, it really goes back to the conflict that Rachel was talking about, this ongoing struggle between California and federal law. And the supremacy clause in the US Constitution and Supreme Court precedent that, again, over the last 20, 25 years have made it very clear that arbitration agreements in consumer actions and in employment actions will be held to be enforceable.
It basically preempts any state law that has a hostility to the enforcement of an arbitration agreement. So any state law, any California law that tries to interfere with the enforcement of these agreements, the argument on one side is the FAA preempts.
So, I mean, with that, with the passage of AB 51, the question then becomes, well, what do we do with these arbitration agreements? So that question was kind of put on ice when the injunction was issued and the enforceability of the agreements continued. We could still, if the employee did not agree to voluntarily submit a case to arbitration, we could still move to compel or petition to compel the court to tell the plaintiff that they need to go to arbitration. And we've been enforcing those arbitration agreements during the injunction. Well, then came a decision from the Ninth Circuit in the Bonta case, which is kind of outlined up on your screen. And the Ninth Circuit did something very interesting. The Ninth Circuit said AB 51's prohibition on mandatory arbitration agreements does not conflict with the FAA because it still allows for voluntary arbitration agreements. However, the Ninth Circuit said, we think, while it's illegal, we think that the criminal and the civil penalties that were associated with AB 51 do conflict with the FAA, and the FAA preempts those provisions. So in essence, what the Ninth Circuit said, and try to wrap your minds around this one, they said the law is good. It is illegal to compel employees to sign arbitration agreements, but there's no penalties. And oh, by the way, if you do make an employee sign an agreement, even though it's illegal, when you later try to enforce that agreement, in a lawsuit, if they sue you later or whatever, the contract's valid and you can still compel arbitration.
You're really threading a needle.
Absolutely. And, there's a great, I don't want to get into the weeds or nerd out too much on it, but there is a great dissent in the Bonta case that I would highly recommend you find online and read. It's only a few pages, but pretty much what the dissent, I think it was a 3-judge panel. And so two on the Ninth Circuit said, that the AB 51 is not preempted and that we can have this. But the dissent pretty much said, look, we've been fighting this fight back and forth between California and the Federal Arbitration Act and the US Supreme Court. This is a fight we're going to lose. Let's get it right. I disagree with how you've thread that needle, to use Rachel's language. And we really just need to recognize that time and time again, not only in California, but across the country, when the Supreme Court is faced with these issues in, like I said, consumer, employment, either class or individual or representative claims, the Supreme Court has continued to hold that the FAA preempts and these arbitration agreements are valid and that the entirety of AB 51 is going to be thrown out. But as of right now, as we sit here today, in May of 2022, AB 51 is technically good law. It is, on the books. It amended the labor code. It does say that it's unlawful and against public policy to compel an employee to sign an arbitration agreement. And so the question then becomes, knowing that and knowing that there are no penalties associated with still forcing people to do it, businesses frankly need to make a business decision. You need to make a decision on how you want to interact with your employees, how you want to deal with potential claims down the road, how you want to deal with an employee who says, you know what, I've heard about this and or my cousin told me about it, and I'm not going to sign it. And how far do you want to go? Does that person then get terminated? Do you really stick with, look, this is a mandatory requirement?
So given that there are no criminal or civil penalties, why don't you talk a little bit about what are the risks to employers of doing it anyway?
So one of the biggest risks, of course, would be if you make an election, and I have clients on all sides of this spectrum. I mean, no one is doing it consistently. It really is based on the business culture of each individual organization. But one of the big kind of risks or issues involved with saying we're going to make our employees, current or onboarding employees, sign a mandatory arbitration agreement is if an employee says no, and you terminate them, you should expect a retaliation claim based on AB 51 that they were, breaking the law essentially. And I said no, then they fired me for it. And so the issue there, of course, becomes if there wasn't another separate earlier arbitration agreement, that retaliation case would proceed in court, and you'd not be able to use the benefits of arbitration. I do want to reiterate, though, that last bullet point, when you're thinking about this with your business folks in your organization, if someone does sign it, even if it's against their will, and you said, look, you have to if you want to keep your job, it's still enforceable. And that's the needle that has been threaded by the Ninth Circuit.
One of the other things, Kyle, that I want you to talk about, because I do think we have the time, is this discussion that we had about what are the options for obtaining signatures, because there are different ways that you can approach this with your HR departments of your own organizations that might yield different results.
Yeah, so I think this is critical when you're thinking about move forward, and you'll see why this is important, because we're going to talk about the Viking River Cruises case, which I'm sure most of you are well aware of in a moment. But it is essential to roll these things out in the smoothest and easiest way for the employee to get the employees to sign as possible. If you have a new handbook, if you have new policies, if you have additional things that you can present to the employee for their acknowledgement along with the arbitration agreement, that of course is best practice. It is not the best practice to call everyone into a classroom setting or do a all company Zoom and say, we have a new arbitration agreement that we need everyone to sign, because you're going to quickly get objectors. I have clients who have employees who work out in the field, they don't work in a physical office, and they brought in a group of 20 of them because they were going to do it. They did not ask for our advice on this. They did it themselves. And they got 20 signatures or 19 signatures. And the 20th person said, well, wait a minute, I don't want to do this, and spoke up. Well, all of the other 19 folks went up and grabbed the agreement and ripped it up. So what you want to do is, if you have an electronic onboarding, if you have the ability to do electronic signatures, which are valid in California and enforceable, you want to do it where the employees are alone, where there's other, like I said, a handbook rollout or other policies that you're also having them acknowledge, so that you can gather maybe not 100%, but close to 100% of your employee population signatures on these arbitration agreements.
And another thing that I'll touch on a little bit more in a couple of slides is, as we discussed at the beginning, ordinary contract principles apply. And so something else to keep in mind as sort of bad practice would be to be hiding these provisions in fine print, deep in an extremely long agreement, or anything else that you could be challenged in court on the basis of unconscionability or fraud or anything like that, for example. So we'll touch on those things as well.
Absolutely. So you might be wondering, why does this matter for PAGA claims? Earlier, we said that under Iskanian, even if you have an arbitration agreement that has a representative action waiver or an agreement to not prosecute a PAGA claim, Iskanian said that's invalid because the state of California is the real party of interest, and because it was not a private action and the state was not a party to the arbitration agreement, then these agreements are null and void, because the state of California can, through their deputized employee, move forward with these cases. Well, Viking River Cruises comes along, and Viking River Cruises is the first time the United States Supreme Court has taken up the issue of PAGA and the arbitrability of PAGA actions. So I mentioned at the top that PAGA was created in 2004. Since that time, 18 years ago, the Supreme Court has been asked on various occasions to look at this issue, look at the arbitrability of PAGA when you have a arbitration agreement with a representative claim waiver. And the Supreme Court has said no. They've said they just haven't taken it up, they haven't touched it. But as Rachel was talking about in the other cases, they have continually said for class action waivers and for consumer and employment matters, they continue to say the FAA preempts state law against arbitration. And so what happened here is Viking River Cruises, which is the company you see advertising on PBS all the time, they have employees here in California, mostly salespeople and some administrative people. I don't think they have any cruises that leave California, but they've got folks here, they've got non-exempt folks here. And one of their non-exempt salespersons sued them. They brought up a PAGA action. And we don't represent Viking in the case, so we don't know all the ins and outs, but essentially what happened was the company decided to challenge Iskanian. And the company said, we think Iskanian is bad law. And so they took the case all the way up to the Supreme Court. And with the changing makeup of this Supreme Court, the court said, yes, we will hear it.
Yeah, and I'll speak briefly to why would SCOTUS not agree to take up similar, if not identical claims since the inception of PAGA in 2004, as opposed to now. And there are a lot of different considerations that come into play. So Kyle mentioned the changing makeup of the court, which is obviously a big one. And we've seen cases be accepted by SCOTUS recently that have not been accepted in decades, perhaps for that reason. And speculation on that would be justified. There are other reasons that the court might not take cases if they're factually complex and the court doesn't think that they would be a good vehicle for their review. They'll refuse to take it for that reason. Or if they think just not enough time has elapsed such that they want to give the lower courts the opportunity to sort of duke it out for themselves and to come to a resolution over time, whether in California courts or in federal courts, they might just adopt sort of a sit and wait sort of perspective. And so, for example, you could imagine if contests to PAGA were raised in 2004, 2005, 2006, the Supreme Court would say, look, this is not an emergency. Let's give this a minute to shake out in real time. But now, as Kyle mentioned, 18 years have elapsed, and significantly, the court looks a lot different than it did then.
And the use of PAGA has exploded as well. And I think that weighs heavily on the court.
Right.
At the beginning, as I mentioned, PAGA was not a mass tort action when it was first conceived by the legislature, and it's become that. And I think that's another reason why the Supreme Court said, well, wait a minute, This is affecting every employer in the state of California. We're talking about millions of employees who might be impacted by this.
Right.
The oral argument was on March 30th. We should have an opinion sometime next month, if not July at the latest. What does it mean and why are we talking? Why are you all here over your lunch hour? This is the most consequential case that we've ever seen from PAGA. It will, if you have arbitration agreements rolled out with a class action and a representative action waiver, potentially completely eviscerate PAGA actions as we know them. If you do not have an arbitration agreement, if there's for whatever reason, if it's just you don't have one, or AB 51 made your organization rethink how you wanted to handle these types of claims, then PAGA cases will still proceed. PAGA will not, this is not an overruling of PAGA, this is not a rejection of PAGA, this is only about if an employee and an employer have a bilateral arbitration agreement with a representative action waiver, if that waiver is valid or not under the FAA. That's the question. So PAGA isn't going anywhere, but the scope of PAGA and the impact PAGA has on employers in California, potentially, if the court comes down on the side that it appears it might, it will significantly change how frankly, the plaintiff's bar addresses labor code violations in California.
And why do we think the Supreme Court might come down in favor of employers on this? We talked about sort of the tug of war and how California courts continue to enact legislation that limit enforcement of arbitration agreements, and then the federal courts sort of respond. So is that sort of the major reasoning that you would say behind your prediction? Yeah,
and you know, they've been hinting at it in a couple of cases over the last couple of years that have dealt with how to handle PAGA type cases in other, not always in the employment context, but in other circuits and in other states. And like I said, the Bonta dissent is worth a read if you've got some time, because it lays that out. It lays out, look, the rest of the panel, the rest of the Ninth Circuit, here's what the Supreme Court keeps saying. And they've been very consistent over the last 25 years. We're wrong. And so that's, I think, why a lot of people are predicting, and frankly, the makeup of the court and the changed makeup of the court, a lot of people are predicting that Iskanian as we know it and the law as we know it here in California will significantly change.
More pro-corporation.
Correct. So what's next? Or what I should have changed this title. What should you be doing right now? Assuming that the Supreme Court will rule in the way that a lot of people think, and that employers will get after 18 years of fighting, a little respite from PAGA. Like I said, PAGA's not going anywhere. The law will still be on the books. It's how do they litigate the claims? You need to make sure that your arbitration agreements, if you do have them, most of them are significantly out of date when we are asked, when we're approached by maybe a new client, hey, can you look at my arbitration agreement? There's been some significant changes to the FAA recently relating to sexual harassment and sexual assault claims, and that needs to be addressed in your arbitration agreements. And then, of course, ensuring that all of the procedural devices that the courts have said you must allow for employees in an arbitration agreement in order for the arbitration agreement to be valid, that you're actually prescribing those in the arbitration agreement and enumerating them in the agreement, so that at the petition to compel stage, at the motion to compel stage, you don't have a situation where a court is convinced that because you didn't spell out exactly what the courts in the California Supreme Court have said must be provided in arbitration, I'm not going to enforce the agreement. You don't want to be in that situation. So now is the time.
Sorry.
No.
So those are the factors, the Armendariz factors, right? Those are the factors that say you have to provide for some form of discovery. You as the employer have to pay all of the arbitrator's fees. And you have to result in a written award that provides some type of judicial review. So those are the pro-employee provisions Kyle's talking about.
Correct. And like I said, you want to make sure that the sexual harassment and assault claims are expressly removed from the arbitration. And that, just so if you haven't been following it closely, that actually was an amendment to the FAA that was passed by Congress and signed by President Biden recently. So that's not a California change, that's a nationwide change.
And what does that say?
So what that pretty much says is if you bring a claim for sexual harassment or assault or claims that are interrelated with those claims, an employer cannot compel those claims to arbitration. Those claims would proceed in court. So what you want to do is you want to make sure that you're working with outside counsel on, updating the arbitration agreements that you might have to handle that. And what I mean by that is, are you going to, sever the claims that are not related to the sexual harassment and compel those into arbitration and stay the sexual harassment claims? Are you going to allow some to go to court and some, to go to arbitration after the court case is over? But you want to make sure that that's all spelled out in the agreement, so there's no question as to how you're going to handle these claims.
Another reason that it's important to continue to pay attention to and update your arbitration provisions is because regardless of what happens in Viking River cruises, the arbitration agreements themselves will still be challenged, even if they include all the required pro-employee provisions that we were discussing, those Armendariz factors. They're still going to be challenged subject to ordinary contract rules, as we discussed at the very beginning of the program. So those types of challenges are many. They include things like the scope of the agreement can be challenged, and that goes a little bit to the sexual assault, sexual harassment claims we were just discussing as to whether the scope of the agreement fairly encompasses or fairly excludes those types of claims. It can also go to issues of waiver, whether the petition to compel arbitration has been timely raised, for example. It can go to duress, undue influence, lack of capacity. Unconscionability, which is an extremely popular one, can be challenged on both substantive and procedural grounds. Also fraud, illegality, and essentially anything else that you could face in an ordinary contract dispute can be raised in the petition to compel phase of the case. Some of these arguments can be decided by the arbitrator themselves, and so it's possible that you could successfully argue and persuade the trial court judge during the petition to compel phase that some of these issues that are being raised by the employee are actually fairly within the scope of the arbitration provision and thus subject to the decision of the arbitrator. And so that's something to consider as well. But ultimately, you're still going to be facing challenges no matter the outcome of Viking River cruises. Moreover, appeals from arbitration decisions will, of course, continue to be exceedingly limited in scope. The statutory scheme does set forth very specific grounds upon which the award can be vacated. And except for those grounds, arbitration awards are essentially immune from judicial review. Those grounds, and I'll read some of them here because, like I said, they're extremely limited. There's just a few. So it says on the screen, legal error is not enough. Legal error, factual error, ordinary abusive discretion, lack of substantial evidence, anything that would make a good, very good, or even excellent appellate argument in the ordinary course simply doesn't apply. You don't get to appeal on the basis that the court made a grave legal mistake. Instead, the grounds are limited to where the arbitrator exceeds their powers. And where an arbitrator exceeds their powers is if, for example, the arbitrator decides issues, claims, matters that were actually not submitted to arbitration. So if the scope of the arbitration agreement is quite limited and the arbitrator just subsumes additional issues, for example, let's say the provision says attorney's fees will be decided after the fact in the trial court, but the arbitrator says, I think I got this, I'm going to decide that issue anyway, that might arguably be in excess of powers. But again, legal and factual error are not enough. Another example is where the award was procured by corruption or fraud or issued by an arbitrator who was bound to essentially recuse themselves based on conflict, and a few other really extremely rare circumstances like arbitrator misconduct. So ultimately, another thing to keep in mind is that based on the extremely limited scope of your appellate rights following arbitration, generally speaking, if, for example, your arbitration provision is not specific to those points, the statutory scheme is going to be extremely limiting. Now, that could be a good thing or a bad thing. If you prevail in arbitration, you might be really glad that the CCP says that the plaintiff in the case has very little additional judicial relief. And if you don't, you might be very concerned and wishing that your provision had included a broader scope or had accounted for additional appellate remedies. And so that's definitely a balancing, like some of the other things Kyle mentioned, it's a business decision in some respects, and it's based on experience. And so that's something to keep in mind as well.
So with that, we came just to 12:52. We were trying to get done at 12:50 so that we would allow time for questions, and we'll have sharing our screen. So if you either want to, I guess, just unmute, or if you want to type in a question, we'd be happy to answer any questions or, discuss anything further.
And of course, to the extent something strikes you later today or sometime in the future, you can reach out to Kyle and me anytime. You can find our emails on the website and just shoot us a question. We'd be happy to continue the dialogue with any of you.
Absolutely.
Audrey warned us that sometimes these can be sort of quiet groups, so don't be shy.
Don't all speak at once.
Don't speak at once. Or alternatively, if you don't have questions because we gave such a flawless program, that's fine too. Audrey, did you have anything that you wanted to say in closing?
Thank you so much for the presentation. You presented a lot of valuable information, and I'll be posting the presentation on our website as well. Thank you so much for your support of ACA.
Oh, it looks like we do have one question here.
It looks like, when will the Viking River Cruise decision might come down? I think, if you look at Supreme Court, what their usual calendar is, it'd be sometime next month in June. We should get it along with the other decisions for this term. But there are, the court has now at this point ended oral arguments. So typically, we could have an opinion at any time.
Yeah, usually in the summer, midsummer. Thank you, Stevie.
Well, great. We really appreciate you guys having us. This was a lot of fun. This is something that you can tell Rachel and I do all the time. And hopefully it was a valuable presentation. You learned a lot. And as Rachel indicated, if you have any questions or want us to clarify anything that we might have said, please feel free to reach out. Our emails and phone numbers are on the website, and we'd be happy to stay in touch. But thank you for having us.
Yeah, this program was basically a prolonged extension of our daily office chats between the two of us. So if you give us a call, we might be in the middle of one anyway. So please give us a ring anytime. And thank you again for having us. It was a pleasure.
Thank you.